Good evening, everybody. So I'd like to welcome you to my lecture called Public Law Through a Feminist Law Lens. And I'm giving this lecture partly because of International Women's Day. And I'd like to thank Maria and the rest of the team and the Feminist Law Society for inviting me to give the lecture this evening. So without further ado then, I'm going to go straight into the lecture and explain to you a little bit about what I'm going to be speaking about. And then I'm going to, first of all, talk about what I mean by feminist and by feminist legal method. And then I'm going to talk about public law, but more specifically, I'm going to focus on judicial review and administrative law. And I'm going to talk about the way that public law and specifically judicial review have been used by feminist organizations and feminist groups as a means of strategic litigation. And I'm then going to narrow it down further, and I'm going to talk a little bit about the judicial review principles and how they've been amenable or can be amenable to feminist method. And then I'm going to go on to talk a little bit about the public sector's equalities duty under the Equalities Act and a little bit about the Human Rights Act to explain how feminist legal method has been used by feminists to progress their aims or ideals. So going to our second slide, I want to talk a bit about what do I mean by feminism and what might be the ways in which feminism can be used to produce results for feminists, for women, and how it can challenge gendered hierarchies. So I wanted to show you this quote, which is by Sarah Ahmed, who's a very well-known, I'm sure many of you will have read her work, feminist academic. And in her book, Living a Feminist Life, she describes what she thinks it means to be a feminist and to be somebody who disrupts and somebody who complains, and somebody who wants to challenge the way that things are. But she also wants to put some joy, I think, into the process of feminism. So she says here, what do you hear when you hear the word feminism? It's a word that fills me with hope, with energy. It brings to mind loud acts of refusal and rebellion, as well as the quiet ways we might have of not holding on to things that diminish us. It brings to mind women who've stood up, spoken back, risked lives, homes, relationships in the struggle for more bearable worlds. So she's really talking about the idea of feminism having a lot of energy, it being a very hopeful movement, but also a very disruptive movement, and one that wants to change things, one that wants the world to be different to the way that it is now. So for me, what is feminism? I would argue that feminism is a practical movement that seeks through theory, politics, culture, law, and other means to expunge gendered practices. And it sets out to imagine and recreate a world without a gendered hierarchy. And legal feminism seeks to interrogate, explore, and deploy law in this broader project. So we need to think about in what ways law can be used to progress feminist ideals and feminist aims to make these kinds of changes. So what are the possibilities and what are the limits of law? And those are some of the themes of my talk this evening. So we've got plenty of examples of law being used as a tool to try to bring about change, to end gendered hierarchies, to end racial hierarchies, to challenge the system. And so you can see here, these are some of the academic works that have been produced, Women and the Law, which came out in the 1980s, which was Lady Hale, and she was then Brenda Hoggett with Susan Atkins and her book. Catherine McKinnon's famous work, American professor, feminist legal theorist, and legal journals which exemplify this movement of women wanting to change the system, feminists wanting to change things. So the Yale Journal there of Law and Feminism, and in the UK, Feminist Legal Studies. So reflecting many of the legal moves, many of the changes, the trying to effect change through law as well as other methods such as politics. So these kind of works are very optimistic about law and think that law can be mobilized or that law can be used to bring about change. So we have to then sound a note of caution, and we can here look at a quote from Audre Lorde, famous Black American feminist professor and prolific writer, who says, "The master's tools will never dismantle the master's house. They may allow us temporarily to beat him at his own game, but they will never enable us to bring about genuine change." So here Audre Lorde is warning us that in order to bring about the kind of fundamental and radical change that many feminists want, that tools like law and politics are never going to be enough. We have to reimagine and think about new ways of doing things. And then closer to home in terms of law, Carol Smart's work, her famous book, Feminism and the Power of Law, published in 1989, was very much a riposte to legal feminists who she saw as being way too dominant. She saw that feminists have been using law, especially in the second wave, or what's sometimes referred to as the second wave of feminism in the 60s and 70s, to try to solve problems. So first wave feminists have been very, very, very absorbed with trying to remove legal obstacles, so to tear down laws that prevented women from entering the legal profession, prevented women from voting, prevented them from becoming doctors, politicians, etc. So they were naturally very absorbed with law because law was an obstacle in their way. And then second wave feminists were trying to use the law to effect change. So we can think about things like the Equal Pay Act, the Sex Discrimination Act, laws on domestic violence, etc. So feminists are very absorbed with legal reform and legal change. And Carol Smart sounds a warning here and says to feminists, stop relying so much on law. Don't look to law. Law over-promises and under-delivers. And so as I summarised here, as Smart pointed out in her key intervention in the 80s, once laws are enacted, they're vulnerable to the interpretation of those who've little understanding of the values of feminism. And so she argued that by over-investing in law reform and legal scholarship, feminists had given too much power to law's claim to establish truth at the expense of disqualifying other forms of knowledge. And she seeks to decenter law and persuade feminists to look to non-legal strategies to solve problems. And she urges feminists to resist the temptation that law offers, namely the promise of a solution. So whilst on the one hand, Audre Lorde says we have to be very careful that the master's tools are not going to dismantle the master's house, and law being very much one of the master's tools that has been used as a method to oppress women. And then Carol Smart saying, look, law can only achieve so much, but we have to be careful not to overinvest and over-rely on it. We must look beyond law and outside of law in order to achieve real change. That said, I think we can say that feminist lawyers may be very well aware of the limits of law, but nevertheless, feminist lawyers have used practically every tool in the legal toolbox to challenge the patriarchal structures of the law and try to inject a feminist perspective. So I think that it's very important for us to always keep in mind the limits of law. And we'll see this in the examples that I give and when we talk about public law. But nevertheless, I think we should still use law as a strategy. We should still use law as a means to affect change. It's one of a number of methods that we should use. And of course, as lawyers, we are very interested in how law should be used. And even feminists like Carol Smart have never said abandon law. They've always understood that law is too important to be abandoned as a site struggle. It's still an area of life that we have to work with and work on, because even if feminists are not interested in law, law is interested in feminists. It's interested in women, in controlling them, and in dictating to them how they should live, and the law will impose its values, its gendered values on women and men, for that matter. So we have to take an interest in law and to try to change law, but without over-investing in law and always understanding its limitations as a tool for change. So having said that, then let's have a look at feminist methods and how feminist methods have been used to explore, to interrogate, to challenge, and to try to bring about change. So this is a rather long list here, so which I apologize for, but it's drawn from various different sources. So what do feminist methods do? And I'll talk in a minute about more specifically feminist methods in relation to law, but many of these methods can be used as we approach law and as we approach public law, as you'll see. So one is asking the woman question: how does this law affect women? How does it affect men, for that matter? How is it gendered, right? What are the gender implications of this law? And later on, as we'll see, how Rosemary Hunter says, how do we include women as well? So we want to question assumptions about the construction of sex and gender roles. Feminists question what's referred to as the Cartesian divide, the difference between body and mind, the rational and the emotional. So the idea that women are associated with the body, which is irrational, it's emotional, it's not quite in control of itself, and men are about the mind and about the rational, and about autonomy and about choice. So feminists want to undermine this divide, which informs so much of our law and politics. Questioning the public and the private divide. So again, traditionally, this is an area that feminists have been very concerned with, to explode the myth that the private, the household, for example, is not an area of public concern, even though it's a site of violence, for example, and a site where real power may be being exercised, economic and emotional and otherwise. Questioning what it means to be a person. So again, ideas about choice, about subjectivity, about rationality. What is a person? And the gendered norms that inform how we think of people. Questioning how law is used. So ideas about rights, how useful are they? What's meant by a harm? For example, feminists have named sexual harassment as a harm, coercive control as a harm. They've given name to harms that largely affected women. The neutrality of law, feminists would challenge the neutrality of law. Questioning ideas about equality. What is equality? And a focus on substantive equality rather than just formal equality. So equality that's transformative, that brings about real change. Feminists will be questioning the interaction between sex, race, class, disability. So critical race feminism and intersectionality are very, very important methods that feminism has adopted. Again, the neutrality of law, the neutrality of the state, and exploring patriarchy. That feminists should root their work in practice and activism. So it shouldn't be purely abstract. So although a lot of feminism is very challenging because it is so theoretical, it should always lead back to a position of practice and activism that will affect real change, real progress for women and men. And feminism can be idealistic and utopian. The idea that things can be different, the world can be a different place. So feminists have to reimagine the world, have to think how it can be different and not just accept the status quo. So for many centuries, people accepted the status quo. They believed certain things about women and believed certain things about men. And it was very often up to feminists to reimagine the world. And again, coming back to the idea of praxis, so feminist ideas should be used to make real change in the world. And then I wanted to just say a little bit about feminist legal method. And so feminist legal method draws on all of these methodologies that we've talked about and all of these ideas. But this comes from Rosemary Hunter's work when she talks about feminist judging. How might feminist judges apply legal methods? How might they infuse legal methods with feminism? And so here are some of the things that she talks about, relying on other feminists, which would be referenced in her work, but asking the woman question and including women. So a feminist legal method would be looking at a legal problem, a statute, case law, precedent. Well, how does this affect women, and how might women be included here if they're excluded? So again, promoting substantive equality and the gender implications of any decision that's being made through the law, and looking at how that might play out. So a reliance on transformative equality, actual equality, not just formal equality, not just naming something as equal, but how might the situation be transformed to actually bring about a position of equality. Reasoning from context and the realities of women's lives rather than abstract principles. So that, of course, we need methods and theories and ideas, but when solving problems, we need to look at the context and reality. And often to look at context, we need to look at social science materials. We need to look at statistics. We need the broader context. So we need to look outside of law in order to be able to apply and understand law. To think reflexively, to understand as lawyers and as judges that how we interpret the world, how we understand the world, how we apply the law and think about the law is rooted in our values, in what we believe and who we are and the experiences that we've had. So if we are a man, we may have a very different idea about applying the law and about its impact and about the values that we're drawing on than if we're a woman or a black woman or a disabled woman. So understanding that we see the world through our own lens, through our own experience, is a very important part of feminist legal method. And also the anti-disadvantage principle, or looking to the bottom, that some feminists have said that it's very, very important to understand how law is going to impact on those who may be marginalised, that may be in a minority, that may be disadvantaged. So these are all very, very important theories and ideas, very practical as well, when we're thinking about feminist legal method and about how we should approach law and how we should apply the law. So having set the scene, if you like, and I'm sorry if I've taken rather a long time to do that, having set the feminist scene, I want to think about how the principles of judicial review can be seen through this lens of feminist legal method. And I'm focusing on judicial review. I'm very aware that public law also includes constitutional law, and we can talk about feminist constitutionalism as well. But in the time that I have, I want to focus on judicial review, because I think it has been a very important site of strategic litigation for feminists who have often mobilized around particular issues of judicial review, and also because judicial review is about holding the government to account. It's about holding public authorities and holding the state legally accountable for its actions. So I think, therefore, inevitably, it's going to be a very important site of challenge for feminists, and I'm going to focus on this. And also, at the moment, I think that it's an area which is under threat from this government which is intending to make changes to judicial review, which may well close down this space as a space for feminist charities, feminist organisations and feminist civil societies who may be seeking to challenge the way that the state is using the law. So that's my justification for focusing on judicial review and its principles and looking at it through a feminist law lens, and to see how feminist legal methods have been used and have impacted judicial review. So first of all, I want to talk just very briefly about some historic approaches to gender in judicial review cases. And so the reason why I want to do this is I want to use this as a way of showing that even when we are applying law, when judges are applying law, judges will always say that they are neutral, that they are not political, in a party political sense, or political with a small p, more generally. What I want to show here is that although judges may not be party political, that when judges apply law, they are drawing on certain values and certain beliefs and principles that they have. And often when they are applying them in relation to women or gender, their views on gender, their views on women are very clear and come through loud and clear. And so I want to just illustrate this by reference to two judicial review cases that you will almost certainly have heard of if you studied public law. So one is the case of Roberts and Hopwood, which, as you may well remember, concerned Popular Borough Council, which was was the first socialist council to be elected in England. What happened was that Popular Borough Council had a statutory power to pay the wages of their workers as they may think fit, as you can see there from the statute from the slide. And so Popular Borough Council decided to pay their workers a minimum wage. And that meant that they were going to pay men and women who did the same job the same wage. And at the time, that was considered to be very revolutionary, because men and women were paid different wages for doing the same job. And that was the way that the market operated at the time. So Popular Borough Council's decision to pay men and women equal wages was challenged by the district auditor, and the case ended up in the House of Lords, where Popular Borough Council was told that it was acting unlawfully, because although it had the discretionary power to pay such wages as they thought fit, the court said that they had to take into account the funds, the ratepayers' funds that they were using to pay the wages. And they also could only take into account relevant matters, and the only real relevant matter was the market rate. So here you can see Lord Atkinson goes well beyond this idea of just sticking to clear legal principles, and he makes his views of feminism known. So he says, by paying men and women the same wage, he says the council would fail in their duty if, in administering funds which didn't belong to their members alone, they put aside all these aids to the ascertainment of what was just and reasonable remuneration to give for the services rendered to them, and allowed themselves to be guided in preference by some eccentric principles of socialist philanthropy, or by a feminist ambition to secure the equality of the sexes in the matter of wages in the world of labour. So you can see there that the actual statute doesn't say anything at all which would be contrary to the idea of paying men and women an equal wage. But the judge there is relying on his own ideology, he's relying on his own values and his own principles about what is a relevant factor and about what is reasonable, to hold that it would be irrelevant and wrong to take into account the idea of equality, which she says is the feminist idea, to pay the sexes the same wages. So very much Lord Atkinson's values are coming through there, and we can see quite clearly what he thinks about feminism and about women. And then similarly, in the case of Short and Poole Corporation, so another famous administrative law case or judicial review case. So again, it's a case where the law itself is neutral. So the law itself, in the way that the statute is formulated, doesn't indicate that there should be any kind of, or there's any right to discriminate against women. So Short and Poole Corporation is concerned with the dismissal of a married woman teacher who's dismissed by the local authority because they have adopted a policy of not hiring married teachers and dismissing any women who become married while they're in their employ. And this is challenged here by Mrs. Short, who thinks that she's doing a very good job, thank you very much, and she'd like to continue in her work, contributing to her family and to her household. And she argues that it's an irrelevant factor and that it's not reasonable that she should be dismissed on this basis. And so here again, you can see the statute is neutral. So the statute says a local education authority may appoint officers, including teachers, to hold office during the pleasure of the authority and may assign to them salaries or remuneration as they think fit, and may remove any of those officers. So again, the law is neutral, but you can see here that the judge is deploying his own values. He's bringing his own values and his own position as a man to bear here, and his own view on who it's appropriate to employ as a teacher by holding against Mrs. Short and saying that it is a relevant factor and that the authority is entitled to dismiss her. So here, Lord Justice Warrington says, dealing with the present matter from this point of view, a determination to employ, as far as possible, women who are devoting their lives and energies entirely to the business of teaching without assuming the privilege and the burden of domestic ties can't, in my judgment, be irrelevant to the maintenance of and the efficiency of the schools or the course of education in the district. So also, if the adoption of the policy in question resulted from a desire that single women might be encouraged to undergo training with a fair hope of employment, it would not, as I think, be irrelevant to the question of efficiency or to the cause of education. So here, Lord Justice Warrington is saying that the authority is acting perfectly reasonably. It's taking into account the relevant factor when it's deciding that it would like to dismiss married women in order to employ single women, because single women who don't have household tasks are more likely to be focused on the job of teaching. And so again, he's bringing his own views here on women and women's position and what it's suitable for them to be doing, and that a married woman can be treated completely differently from a married man in terms of being dismissed. So having seen the way in which judicial review principles can be used in order to produce what we would say is a very sexist result, let's have a think now about how those same principles could be used in a way that is more progressive, or perhaps is more of a cause for hope. Because it's International Women's Day, I'm going to be more optimistic. I'm going to look at cases that have been successful rather than those that are failures. But I think we always have to keep in mind the limitations of judicial review as a strategy. So, of course, as we've been reminded by Carol Smart, when laws are passed, they are interpreted by judges, and judges often have their own view about gender, and in the past and sometimes in the present are often very sexist in the way that they apply law, and we have to keep that in mind. But nevertheless, judicial review principles have been used in order to lead to progress, and judicial review and challenging public authorities, challenging government has been used by feminist organisation, by women's groups, in order to progress to bring about change. And we can see that in the next few cases that we're going to look at. But again, I do just want to stress that judicial review is a remedy of last resort. It's very expensive. You might be liable to pay the cost of the other side if you lose. It's quite limited in its effect, because it can well be that even if you win a victory on judicial review, Parliament might change the law in the future, so your victory may be very Pyrrhic. Or if a decision is challenged, it may just go back to the public authority, who may make a similar decision again. So there are lots and lots of limits of judicial review as a mechanism of strategic litigation. There's also the danger that if you lose your case, you're setting a bad precedent for the future, and the government might regard it as a moral victory. If they've won, they may well use it as a way of strengthening their position. So there are all sorts of dangers and disadvantages with judicial review, and I'm in no way advocating that it is a remedy that you should rush out or be advising people to use. That isn't what I'm getting at. But what I'm trying to show is that when it has been used, it can be used in a way that does lead to change, and it can be used as a mechanism of challenge. So let's have a look at two cases which are relatively optimistic, where there has been a relatively good outcome. So one case here which used traditional judicial review principles to argue in favour of legal aid being granted in cases of domestic violence is the case of the Queen and the application of rights of women, and the Lord Chancellor and the Secretary of State for Justice. So this is a case which is concerned with the government's austerity agenda, the coalition government in 2010, and the passage of LASPO, the Legal Aid Sentencing and Punishment of Offenders Act, which severely cut legal aid. And essentially, there were major cuts to the granting of legal aid in family law cases, and there are only really very few circumstances where legal aid is available for family law disputes. However, the government did state that it was intending to protect those who are survivors, victims of domestic violence, and that they would be entitled to legal aid for court proceedings. And so this was incorporated into the legislation, which did provide that legal aid should be available in cases of domestic violence. Now, when the government later went on to produce its regulations, which were later approved by Parliament as delegated legislation, there was a condition that if you were a victim of domestic violence and you were involved in a family law dispute and you applied for legal aid, that you had to produce documentary verification of the domestic violence within a 24-month period. And this proved to be a real obstacle for many women who wanted to claim legal aid, because quite often, for all sorts of reasons, the domestic violence had occurred outside of the 24-month period. And it may be that the dispute with their ex-violent partner had been dormant for a while, and the dispute had been sparked by a custody dispute over a child, or the partner had been in prison. So it could be all sorts of reasons why there wasn't evidence of documentary evidence available. And so rights of women used traditional judicial review principles to challenge this decision and to challenge this delegated legislation. And they argued that this 24-month requirement of documentary evidence frustrated the purpose of the legislation, because the purpose of the legislation was to provide protection for those who had suffered domestic violence, so that they would be able to have legal advice and representation for a family law dispute, largely so they wouldn't have to represent themselves and to face the perpetrator of the violence against them in court. So they argued, using judicial review principles based on Padfield, that this delegated legislation requiring the 24-month documentary evidence was contrary to the purpose of the statute. And they were successful in the Court of Appeal. So they had to appeal. They went to the Court of Appeal and they were successful. So here you can see the judgment in the case, and the Court of Appeal saying that, and the judge saying, I would conclude that subject to one point, Regulation 33 does frustrate the purpose of LASPO because it imposes a requirement, the 24-month requirement, that makes no provisions for the victims of financial abuse. So basically the court there is applying the principles in Padfield to find that there's been a frustration of the purpose of the legislation. So here you can see in an interview the Director of Rights of Women, who were responsible for bringing the case, talking about the case, saying that using judicial review is ultimately one of the ways we can bring about real change for all women, as opposed to the individual interventions that our direct services produce. So we will continue to seek to influence changes to legislation as we have in the past, but we remain committed to using challenges that change regulation and the law. So here Rights of Women were intervening in order to challenge the way that the law had been used to provide an obstacle to women obtaining legal aid, and they were successful doing this using the traditional principles. But there's a couple of things here that are useful to point out. So one is that they're acting as a Rights Women is a charity, it's a non-governmental organisation, and so it's using the broad rules of standing that are provided for on judicial review in order to bring the claim. And the reason why I'm mentioning that is because there is some concern that the government is going to try to introduce legislation to narrow the rules of standing. So that's one point to think about there. And also that it's using its position as a group which has a good deal of experience, Rights of Women. It has a hotline and it works on issues of violence against women. It's using its experience as a pressure group, as a non-government organisation, as a group that gives advice. It's using its experience with women, presenting that experience to the court to show the actual impact that this delegated legislation will have, and how it's going to undermine the legislation which is to provide legal aid for domestic violence. So it's using its experience. And then thirdly is acting as a test case, because it's challenging the delegated legislation. And obviously the impact is going to go beyond one individual. It's going to impact on many, many people. So it's serving a very important function here by bringing the challenge. So one is taking advantage of the broad rules of standing, which allow pressure group charities to bring a challenge rather than forcing individuals to bring the challenge. Number two is acting as a test case. So the case is going to have an impact on a large number of people. And then thirdly, it's bringing its experience as a group which works on issues of violence against women and works on women's rights, and it's bringing that experience to the court. So I think here you can see that judicial review is being used as an important space here that feminists are occupying in order to try to move forward, in order to progress their aims. Okay, so the next case that I want to talk about, with a positive result, is the case of Yemshaw and Hounslow and London Borough Council. So this is a housing law case. It's not brought through the judicial review process, but housing law uses a lot of the same principles of judicial review. And it's also a public law matter because, of course, it's a case which is being brought against the local authority, in this case, Hounslow. So this case, again, is a slightly different case. So in the case we looked at with Rights of Women, it was the women's group, Rights of Women, who are bringing the case. But in this case, in Yemshaw and Hounslow, London Borough Council, the case is brought by the individual who has suffered the wrong. So here what's happened is that, so Mrs. Yemshaw was living with her husband, and she felt under threat from her husband, who had threatened her, had intimidated her, had been withholding finances from her, threatening to take away her children, and denigrating her, putting her down, etc. And so she felt she could no longer tolerate the situation. She felt threatened, and so she left. But when she claimed for housing from the local authority, she was in danger of being considered to be intentionally homeless and therefore not eligible for housing. And that in order to be eligible for housing and not deemed intentionally homeless, she would have to have been considered the victim of violence in her household, and she would have had to have been someone who would have had to have left her home because of violence. And the term used was violence, and the term was used in Section 1771 of the Housing Act. And the issue was that up until this point, the term violence was interpreted to mean physical contact. But the question that arose in this case was, well, there wasn't any actual physical violence, although she felt intimidated and threatened with violence. There was no actual violent conduct. So could the word violent also include psychological violence, economic pressure, economic violence, and intimidating behaviour that occurred in this case? And in this case, Lady Hale, who gave one of the leading judgments in the case, said that she thought that the term violence should be given a broader meaning, and that even if, when the legislation was passed in 1977, even if it wasn't considered to be, violence wasn't considered to include broader elements of economic, psychological violence, that its meaning had changed over time. And so you can see there from the quote, she says, "It's clear to me that whatever the position was in 77 when the original legislation was passed," she says, "the purpose of the legislation would be achieved if the term domestic violence were interpreted in the sense in which it's used in the family division, that domestic violence includes physical violence, threatening or intimidated behaviour, or any other form of abuse, which directly or indirectly may give rise to the risk of harm." So here Lady Hale decides that the term violence does include threatening behaviour and other kinds of abuse, which may lead to the risk of harm. And by saying this, by adopting this broader interpretation of violence, it means that the claimant then is able to obtain housing, and that she will not be deemed to be intentionally homeless. So it's very, very important practical result by giving the term its broader meaning. Now, just dwelling on this in terms of feminist legal method and looking at violence, looking at domestic violence, looking at public law through a feminist lens, there's a couple of things to here to note, to pause and to talk about. So one is that in this case, there was a third-party intervention by Women's Aid. So whereas we saw Rights of Women bringing the case in the previous example here, we can see the case brought by the claimant, but she is given support by feminist organisation, by women's organisations who intervene. They put their views before the court in a third-party intervention, explaining why the term violence should mean psychological violence, and it shouldn't just be restricted to physical harm. And so here Lord Brown refers to Women's Aid intervention as part of his judgment, saying it's long been known that psychological abuse within a domestic context can cause at least as much long-term harm to the victim as physical harm, and no one who's read the extensive material put before us by Women's Aid Federation of England could fail to appreciate that fact. So here you can see that the judgment is very contextual. So it's looking more broadly at the social factors which are presented by Women's Aid, and relying on that to come to a better contextual understanding of what domestic violence is and what violence means and how it should be interpreted. And another factor to point out here is that the court relies on jurisprudence and documents and treaties such as CEDAW, the Women's Convention, which are international legal instruments which have also developed definitions of violence to include psychological violence. So again, these are very hard fought for gains that women's organisations and feminists have fought for in the international sphere, so that international treaties dealing with discrimination against women have these broader definitions. And here we can see the domestic court drawing on those. Okay, so you can see here that there is a level of reliance on international law, on international human rights law, in order to enrich the domestic law and come to a more progressive interpretation of what we mean by violence. And that this is done through the third-party intervention of Women's Aid Federation. And again, third-party interventions are creating a space for feminists, creating a space for women to present their view to the court, to try to inform the court of the consequence of the change in definition, or in providing a broader definition rather than a narrower one. And I also think we have to have a shout out for Lady Hale here for her feminist judging. So again, she's looking at the actual experiences of women. She's actually looking at how the law can be interpreted, how the law can be used here. So she's using strict legal methods. She's using a purposive approach, but she's also infusing it with feminist legal methods as well. And I think that's really important. And I think it's important at this point just to say that we're not saying that, or feminists are not saying that judges can just decide cases in any way they like. They can decide using, they can predetermine the result, that they're going to be biased, etc. I think what feminists are saying is that there is a room for manoeuvre with application of legal principles, that judges are bound by precedent, they're bound by legal principles, they're bound by legal values, but those values are pliable and flexible. There's some room for manoeuvre. And where there is this room for manoeuvre, they need to adopt feminist legal methods. And this feminist legal method is going to lead them to a better conclusion and a better outcome, especially for women, than if they apply the law in what they may see as a neutral way. But that neutral way is full of, it's full to the brim with other values which may not be feminist in nature at all. So this case, I think, is a very significant one for feminists, because it's a good example of feminist judging. It's not without its critics from black letter lawyers who dislike the purposive approach that is adopted in the case. But I think we can see here that it's a very experiential method, and it is a method that is often used by judges. It's a perfectly respectable method to lead to a particular outcome. Okay, so having shown how public law can be used, traditional public law principles can be used, and they can be deployed in order to achieve important results for feminists. They can be used as a way to challenge patriarchal ideas. I want to turn now to another method which has also been used through the judicial review process, and this is the public sector's equalities duty. So the public sector's equalities duty was consolidated in the Equalities Act of 2010. Previously there were equalities duties in the sex, race and disability legislation. The Equalities Act consolidated that legislation, and it produced the public sector equalities duty. And the public sector equalities duty places a obligation on public authorities to have due regard to the need to eliminate discrimination, advance equality, and foster good relations between those in the various protected categories. So age, disability, gender reassignment, pregnancy, religion and belief, sex and sexual orientation. So essentially the public sector equality duty, the idea of the public sector equality duty emerged from the Stephen Lawrence inquiry. It's a method of trying to challenge institutional racism, institutional sexism by getting public authorities to think about equality issues when they are carrying out their functions, when they're developing policies, when they're developing new practices. So the idea of the public sector equalities duty is that it's trying to deal with the problem of say sex discrimination or race discrimination by asking the authority to examine its own practices, and whenever it develops new principles, new policies, it drafts legislation, that it has to have due regard to these factors or these needs to try to eliminate discrimination. Now, the weaknesses of the public sector equality duty are that it is only a duty to have due regard. It's not a duty to actually achieve equality or to give equality a priority. It's a duty to consider, essentially. And if the authority fails to give effect to the public sector equalities duty, so in other words, if it fails to have due regard, then it can be challenged through judicial review. So again, all the same caveats applied, that it can be a very Pyrrhic victory, because it may well be that even if you win your claim and the court decides that the public sector equalities duty hasn't been considered, the authority may well go back, reconsider its decision, take into account the equalities duty, have due regard to it, but come to the same conclusion. And so you're not in a better position. But nevertheless, there are examples, again, where women's organisations have used the public sector equalities duty to good effect. So one of the earliest example was Southall Black Sisters' challenge to Ealing London Borough Council's decision to terminate the services of an organisation, in this case Southall Black Sisters, who were providing services for black women and Asian women, so BAME women in the area, and instead to move to having only one service provider giving advice to women on domestic violence, and that service provider would provide advice and help to all women. And so Southall Black Sisters challenged this because they said that Ealing had failed to give effect or to have due regard to the principle of racial equality, and it had failed to consider that its policy would have a particular impact on BAME women, and it had failed to carry out an equalities impact assessment. And so here, in fact, the local authority backed down and reinstated their grant to Southall Black Sisters before the case actually started. But in any case, Southall Black Sisters won their claim because the court said that they had completely failed to consider the impact of their policy on Black and minority women. So you can see there from the judgment of Lord Justice Moses saying, once the Borough of Ealing had identified a risk of adverse impact, it is incumbent on the Borough to consider the measures to avoid that impact before fixing on a particular solution. It erred in having recognised the problem while merely hoping to assess its extent after it has settled on its criteria. So in other words, it was just going to impose a policy and then afterwards try to justify it. And so again, here you can see a women's organisation, so a civil society organisation challenging the decision through judicial review, and having a successful outcome here. Another case, which is a rather quirky, I think, and interesting case, again brought by a women's organisation, is the Fawcett Society. So in this case, the Fawcett Society is challenging the budget. So yes, you heard it correctly. It is the budget. This is the budget which the Chancellor is introducing in order to implement the coalition government's policies of austerity after the financial crash. And again, here, the Fawcett Society are arguing rather cheekily, I think, that the budget is unlawful. And the reason why they're arguing that the budget is unlawful is because there was a failure to carry out a gender equality impact assessment of that budget and its impact on women. And again, here, the case is unsuccessful in this case, and the court refuses to grant a remedy, and it refuses a permission for the case to go ahead. But it's largely because the budget had already been passed, and it could not sensibly be unpicked. But I think what's important about the case here is that Fawcett, again, got a lot of publicity in the way that other cases have got publicity, like, for example, the Rights of Women case, they get a lot of publicity for bringing the case. But I think beyond that, the case is important because it does very clearly establish that even an act of high policy of government, such as producing the budget, which is very high profile, receives considerable publicity, it's really heavily scrutinised, that even producing the budget, that the public sector equality duty applies, and at some stage, at which stage is disputed, but at some stage the gender equality impact has to be considered. And I think that in itself is a very important acknowledgement, and it's very important that was stated by the court, even though Fawcett were ultimately not successful in the claim. So again, focusing on the more optimistic aspect of the public sector equalities duty, and continuing on that note, the public sector equalities duty has come in for a lot of criticism because it hasn't been transformative enough, and because of the reasons that I mentioned earlier, that it's only a duty to have due regard, not to actually affect change. But in this article, by Lucy Vickers and Kate Clayton Hathaway, they point out that the public sector equality duty is really very significant there, because they say that it's underpinned by a transformative model of equality based on the idea of inclusion, the aim of ending marginalisation and disadvantage and promoting social justice. So it's equality based on social inclusion can be achieved by encouraging minority or disadvantaged groups to participate in civic life so their voices can be heard and become stronger. So what they're pointing out here is something quite similar to what, in a sense, what Carol Smart was saying, which is that, law in itself, in terms of bringing litigation, is not necessarily going to bring about the change that feminists want, but by bringing marginalised groups into the policy making process, by bringing them into these political processes, that might bring about change. And what the public sector equality duty does is it forces the public body, it forces the authority to think about equality issues, even if it then doesn't end up pursuing them. It has to at least consider them, and by considering them, it's being reflexive, and there's a greater chance for groups to participate, marginalised groups to participate in that policy making, and therefore it does leave open the door or the possibility of change occurring. So I'm going to move on from the public sector equality duty, and I'm going to talk about another piece of legislation, again, that has been implemented through the judicial review process, and that is the Human Rights Act, which again has been the site of important litigation, has been the site of important strategic litigation, not always successfully, but occasionally successfully. But again, it's a space that feminist groups, feminist organisations have tried to occupy to try to effect change, to try to reshape the law in a way that is progressive and that vindicates the rights of women and challenges gendered hierarchies. So just very briefly then, as you know, the Human Rights Act brings the European Convention of Human Rights, it transposes it into our domestic law and makes it enforceable. In accordance with Section 6 of the Human Rights Act, public authorities have got a responsibility, a duty to comply with the principles in the European Convention on Human Rights, unless there's primary legislation that prevents them from doing so. And it gives various powers of the court, even in the case of primary legislation, to make a declaration of incompatibility, although it's then up to Parliament to decide whether or not to change the law. But the European Convention on Human Rights itself has been used as a tool by feminists in order to try to effect change and to make human rights themselves more gendered. So human rights, sometimes referred to by some feminists as men's rights, there's had to be a concerted effort by feminists to try to include women's concerns within the human rights canon. It hasn't just happened. It's happened because feminists have pushed for it to happen. Feminist activists, feminist lawyers have pushed and have brought cases and have passed laws, have tried to produce legal instruments like treaties, worked on the national, the international, the European level to try to infuse human rights with this gendered element. And so you can see that at the European Court of Human Rights level, this happened to some degree. So, for example, in Aydin, Turkey in 1996, the court accepted that rape could be a form of torture. In MC and Bulgaria, the court develops out of Article 3, which prohibits torture and inhuman and degrading treatment. The court develops out of Article 3 a positive obligation on the state to criminalise rape and to provide effective methods of investigating rape. And then in Opus and Turkey, again, the right to life, the right not to be subject to torture or inhuman and degrading treatment, the right not to be discriminated against. In this case, again, the court uses these rights to say that the state has got a positive obligation to protect against domestic violence and to have laws which are effective and investigative processes that are effective. And then we see this law being used within our domestic law through the Human Rights Act in the case of DSD and MBV, which are cases which are concerned with the John Warboys case, the taxi driver who drove a black cab, who was guilty of serial assault and rape against women. And there was a real failure of the police to conduct an effective investigation. This mode of offending went on for years. Even though it was reported, the police failed to take it seriously. And in this case, in the case of DSD and MBV, the court in this case awarded damages against the police under the Human Rights Act, under Section 8 of the Human Rights Act, because of the failure to properly investigate. So using Article 3 here, the court saying that there's a positive obligation on the police to investigate properly, and if this doesn't happen, if there is a systemic or operational failure to investigate, then in those circumstances it can give rise to a claim for damages. So we can see here that the European Convention on Human Rights is important in terms of producing these gendered outcomes. Okay, so I wanted to just throw this in here. Lady Hale, in her application of the Human Rights Act, whenever there has been the opportunity, trying to develop principles of equality and infuse the Human Rights Act with feminist judging. So here, in Gaydon and Mendoza, an important case which is concerned with gay rights, she says that it's the purpose of all human rights instruments to secure the protection of the essential rights of members of minority groups, even when they're unpopular with the majority. Democracy values everyone equally, even if the majority does not. So the Human Rights Act, through its the application largely of Article 14 in conjunction with other articles, has been used to a certain degree to promote the ideas and the values of equality. Okay, so now I want to turn to some difficult cases under the Human Rights Act, where I think the results have been rather mixed for feminist and other civil society organisations. But these have been challenges using Article 14, the right to equality and not to be discriminated against in the application of rights in the Convention, to try to challenge some of the consequences of austerity, the austerity that was imposed by the coalition government, the Conservatives and the Liberal Democrats, from 2010 onwards. And these were largely challenges that were brought using judicial review procedures, and the most famous cases, which are ones which I'm going to talk about very briefly, are the benefit cap and the bedroom tax cases. So the benefit cap was the cap which was imposed on benefits, which was a sort of an average amount that was chosen, and then this cap was imposed in order to make sure that people on benefits were never better off than those who were working. And then the infamous bedroom tax, or the spare bedroom subsidy, where people who were receiving housing benefit but were deemed to have be living in a house or a flat with too many rooms for their needs, were then being charged extra rent, or rather not extra rent, but rather their benefit, housing benefit, was being capped. So both of them were basically part of the austerity agenda to cut the welfare budget, to make sure that people in work were always better off than those who were not in work, and that if you reached a certain level, that your benefits would be capped unless you could work, I think it was 16 hours or more a week. So these policies were all challenged in various ways through judicial review. And usually as the delegated legislation that implemented these policies that was being challenged through judicial review. Okay, so I just want to say very briefly why I think this is a very important issue for us to consider when we're thinking about judicial review. We're thinking about feminist legal method and whether or not it can make a difference. I also think it also illustrates the limitations of law as well. So some of the things that Carol Smart said about law having its limits, I think we can see them very clearly here. So essentially, the austerity agenda had a disproportionate impact on women in various different ways. So there's a quote here from Yvette Cooper, who was the in opposition, challenging the coalition, saying, and there's a report here saying, Cooper accused the coalition of sanctioning a budget whose impact fell disproportionately on women. The gender audit of the budget conducted by the Commons Library showed that more than 70% of the revenue raised from direct tax and benefit changes is due to come from female taxpayers. And of the nearly 8 billion revenue to be raised in the financial year, 6 billion will be from women and 2 billion from men. Again, just looking down the page a bit, in terms of the welfare cuts, saying of the 16 billion being raised in the current parliament, 12 billion is coming directly from the pockets of women. It includes changes to universal credit, childcare support and child benefit. So I think a lot of the impact of austerity was felt by women who often are quite reliant on public services, who often work in the public sector, and who may often be dependent on welfare. Okay, and again, just making the point that this impact of austerity was particularly harsh on Black, Asian, minority, ethnic women. So you can see here some statistics saying Black and Asian lone mothers stand to lose £4,000 and £4,200 a year on average by 2020 from the changes since 2010, about 15 and 17% of their net income. So again, disproportionate impact on women, but on particularly on minority women. So there was every interest in challenging the austerity agenda wherever possible, through the political process, but also through the legal process, because much of it was effected through the judicial review process. And so it is often being argued that these policies were discriminatory in various different ways. So just some reflections on the benefit cap and the spare bedroom tax cases. So in these cases, the claimants are largely using equalities law to enforce socio-economic rights, but socio-economic rights are often regarded as the poor relation of civil and political rights, and that the claimants had quite limited success using Article 14 and also using the public sector equalities duty. That in these cases, the courts applied a much stricter test. So it was harder to get the court to intervene in these cases, because it wasn't just a proportionality test that the court was using. It would, in order for the court to intervene, they said that the policy or the practice had to be one, even if it discriminated, it had to be one that was manifestly without reasonable foundation. So the reason for this is because the issue is so politicized, and the courts are often very reluctant to intervene in cases concerned with welfare benefits, and they tend to defer to the executive and parliament. So even though there were very clear inequalities that are shown in all of these cases, in almost all of them, the claimants lost because the court decided that it was going to defer to the executive. And it's really only Lady Hale, to some extent Lord Clare, in some cases, in one case Lord Camworth, who take alternative approach. But I think Lady Hale's approach is a really standout approach, and she's dissents in nearly all of these cases, because she tries to prioritize equality, which she says is a constitutional principle. So I would argue that she's applying feminist legal methods in most of these cases to try to come to a decision which is favourable to the claimants who are challenging the implementation of these very harsh welfare policies that are clearly having a disproportionate impact on women. But mostly the claimants lost. But there is one case where there was some success. So this case was the case which is called A, is referred to as A. The full reference is back here, so the Queen and A, and the Secretary of State for Work and Pensions. And these cases were heard together with several other cases, which makes them all very complex to get your head around. But essentially, I'm just going to focus on this one case and not on the other cases which were concerned more with disability discrimination. But in this case, it's concerned with the Welfare Reform Act, which was subsequently implementing the bedroom tax through the housing benefit regulations. And so essentially what happens in this case was that, this is the one case that ultimately was successful, but it was a very long journey. So what happened in this case, it was concerned with A, who was a single mother. She'd been a victim of domestic violence, but the violence had been so severe that she had been, there had been an arrangement with the police and social services that she was going to live under a sanctuary scheme, which meant there's a room in her house which was a safe room that she could retreat to if she was violently attacked. However, when the bedroom tax came in, she was subject to the bedroom tax, which meant that she would receive a reduction in housing benefit unless she was granted discretionary housing payment. And so it is argued that this is a breach of her rights under Article 14, the right not to be discriminated against, along with Article 8, a right to family life. And in the domestic court, in the Supreme Court, A lost her claim. So she lost her claim under Article 14 and Article 8 because the court said, well, although it does impact on her, it does impact on her as a victim of domestic violence. The court said, well, it could be dealt with through her being granted discretionary payments. So you can see there that she felt safe and her property was adapted. She didn't want to move, but she didn't actually need a larger flat, but she'd been allocated this flat by the council because there wasn't another flat available. There are only a small number of people, mainly women, who were subjects of a sanctuary scheme. And although it was, you could see there was discrimination, it could be justified because it could be dealt with through these discretionary payments. So the majority said it ultimately wasn't discriminatory and there was no breach of Article 14. They also said that there was no breach of the public sector equalities duty because there was an equalities impact assessment on gender, although it didn't specifically deal with domestic violence, but the court said there's only a small number of people. But I think in this case, it's interesting to think about the dissenting judgment of Lady Hale and Lord Carnwath, who also agreed with her dissent. And she said, I won't go through all of the points that she made, but I think the main one, and the one I want to stress, is that she says the state has got a positive duty to protect against gender-based violence. And as part of its positive duty to protect against such violence, so sometimes it needs to treat people differently. So it needs to treat somebody differently in order for them to be equal. And that it can't be dealt with by just giving her a discretionary payment, because the reality is that a discretionary payment is discretionary. She have to apply for it every year. It's a short-term solution. And as somebody who suffers domestic violence, she needs to be treated differently. Otherwise, she's being discriminated against, and the state is not fulfilling its positive obligation to protect her from gender-based violence. And also, for good measure here, the dissenting judgment thought that Lady Howe thought there was a breach of the public sector equalities duty, because, again, she said that the needs of those who might suffer gender-based violence should also be specifically taken into account. So although A lost in the domestic courts, she did take her case to the European Court of Human Rights, where ultimately she was successful. And so here you can see from the quote saying that the government, this is a UK government, haven't provided the European Court of Human Rights with any weighty reasons to justify the prioritisation of the aim of the scheme over that of enabling victims of domestic violence who benefited from the protection in the sanctuary schemes to remain in their own homes safely, and that the discretionary payments couldn't make up from it. So in other words, the court said that the sanctuary scheme should have been prioritised, because the purpose of the sanctuary scheme was to allow people to stay where they were, whereas the purpose of the benefit tax was to get people to move to smaller accommodation or to pay more money. And the court said it just didn't make any sense here, and ultimately it was discriminatory against A. So I think it was a happy result there. But I think one of the things that I wanted to stress was the limitations or the difficulties of trying to enforce the rights here, trying to enforce these socio-economic rights, which are doing real harm to women. There's no question that they were being discriminated against in reality, if not according to the court in law. But the court really just refusing to adopt methods which would have feminist legal methods, which would have led them to a different conclusion. So I think, what can we learn from this? So I think maybe going back to where I started from, to think about what Carol Smart says, what Audre Lorde say about the limitations of law. We have to keep in mind that law is limited in what it can do, that there are going to be other methods, other mechanisms that we need to use. We need to be very creative. We need to use other spaces as well. We need to use every political space, every artistic space. We need to use all media. We need to win people's hearts and minds to get them to really understand what the issues are that feminists are trying to grapple with and trying to bring about change. So we need to go way beyond law. I think there's no question of that. And we can see the real limitations of law when we're looking at some of these cases which tried to challenge issues of austerity through the courts, through the judicial review process, and largely failed, although there was a good result in the case of A in the UK when she finally managed to get her case to the European Court of Human Rights. But nevertheless, I would argue that judicial review is still a very, very important space for bringing about change, and is still a very important space for feminists. And I think one of the reasons why I wanted to really stress this is because I see this as a space that the government is trying to close down. First of all, it attacks civil society. It tries to silence the voice of civil society in various ways through different pieces of legislation, which go beyond points that I've made in this lecture, but I do elsewhere in my research. But coming back to judicial review, I think that the government has instituted this independent review of administrative law in 2020, which has reported, although we don't know what it's reported yet, and it's committing itself to rebalancing the relationship between the courts and the executive and parliament. And it has criticised activist lawyers, criticised activist judges. So in other words, it wants to make itself less accountable. And it is likely that that the way that judicial review may be closed down will be narrowing the rules of standing so that groups like Rights of Women can't bring challenges, narrowing third-party intervention so that groups like Women's Aid can't intervene to explain the actual impact of a definition of violence and what violence may actually mean in practice, so that the court can define violence in a way that is effective for women who need to rely on the law. So by changing the law in relation to standing, changing the law on third-party interventions, by criticising activist lawyers for wanting to intervene and preventing test cases, by doing all of these things and by closing down these spaces, it's shutting feminists out, is shutting women out, is trying to push them away and to make the government less accountable. Similarly, with threats to the Human Rights Act and to equalities legislation, and the Human Rights Act again is currently being reviewed. It may be a difficult space sometimes, as we've seen, but it has also been a space where there have been positive results for feminists. And we've seen that with the decisions of the European Court of Human Rights and with some of the judgments, for example, the Mendoza and Gaydon judgment and Lady Hale's comments there. And just to reinforce this as a final quote, this is a quote from Women's Aid in their response to an earlier government consultation on judicial review, explaining why they think that judicial review is very important. So they say Women's Aid greatly values the current judicial review system in enabling the voices of women experiencing domestic violence to be heard in cases of public interest. Any changes to the standing for judicial review or cost of interveners will impact on charities representing the most vulnerable in society and will cut off their voices from being heard. So, in conclusion, I think that it's very important that we think about judicial review and about administrative law as an important space for feminists and for civil society, for women's organisations, for hearing women's voices, for allowing women's voices, for allowing feminist legal methods to percolate through the legal system. And I think that we should all be very aware and very worried about this space closing down. And if we have any opportunities to speak out against this on International Women's Day or on any other day, then we should do so. So I'm going to end there. So once again, I'd like to thank the organisers for giving me the opportunity to give this lecture. I've also taken the chance to provide you with some of the references to my articles and to my work on feminist legal method and on judicial review and different ways in which feminist ideas can influence and shape the law if you want to read further. So happy International Women's Day, happy feminist activism, and thank you very much.